Hey guys, welcome to a very special not episode of Let Them Eat Bread. Although there's no episode this week, I did want to talk about the leaked memo from the Supreme Court concerning Roe versus Wade. There's going to be a lot of talk about it, but as well as being a baker and a privacy professional, I'm also a lawyer, right? So I wanted to talk about this from both a legal and a political perspective, and I didn't want to wait until our next episode to do it. One quick note before I get started. Two quick notes. One, I have a lot of points to cover. I don't really know how long this video is going to be, so tune in, tune out, do what you want. This will appear on YouTube when it's done. And I'm just going to work through my points, and hopefully it all kind of logically makes sense. Point number two, I'm sitting in the middle of a giant storm, so it's entirely possible that my power goes out at some point. It went out a bunch yesterday. I'm dog sitting right now. I'm not at my usual place. So if we lose power, don't worry about it. I will rehash. If for some reason this gets disconnected, I'll just rehash all my points on the next episode. But I did want to try and talk about it right now. So first and foremost, so this is not something that everyone really wants to hear, but abortion is truly a culture war issue. But it has economic implications, right? So the reason that we even talk about abortion in the first place is because there's a certain group of people in this country who are trying really hard to push the abortion is bad thing on us. There is no political implication outside of that group, but if those people win, specifically right-wing evangelists, you are really going to hurt a lot of people economically, because the inability to abort a fetus, or to abort the possibility of having a child, is forcing on people the economic ramifications of having children, which is oftentimes 18 years of economic responsibility. And with prices going up, and with just the general cost of healthcare and schooling and daycare and all those things, that type of economic impact on an individual or a couple can be, backbreaking in a sense, right? It can really destroy people economically. So you want to make sure that if you want to have children, that you're also financially ready to do that, right? And so abortion allows you to go into that decision that you might have to make, if for some reason you become pregnant and don't want to, or your birth control fails, or whatever it's going to be. Do you have the financial capacity, economic capacity, to take care of that child, right? So I don't want to say that, it's a cultural issue with no economic implications. It definitely has economic implications. And for those people who are forced to carry a child to term, it has tremendous economic implications. Plus, of course, we can talk about the health implications, yada, yada, yada. But I just want to get that out of the way. Truthfully, it is a culture war issue being pushed by the right wing, but we on the left should treat it like an economic issue, because it's an economic issue. It's also a bodily autonomy issue, yada, yada. But we're kind of, this is the way that we should fight the culture war, right? If we're going to fight the culture war on the left. So that's the first point. The next thing I want to talk about is, again, probably not going to be particularly popular opinion of mine, but the leak of the Supreme Court is actually a bad thing, and we should be talking about it, but not as much as we talk about the actual implications, the context of the leak itself, right? So why is the SCOTUS leak bad? So the reason the SCOTUS leak is bad is because in the way that courts work, and this is all courts, it's not just Supreme Court, the opinion is assigned to a judge or justice, who then writes the first draft, and then they try and negotiate to get votes from other members of the court. So if you write a particularly strongly worded draft of something, that's really just the first draft. You're essentially testing the waters, right? And you send it out to the other colleagues on the court, and you essentially say, hey, would you vote for this version of it? Okay, so then you can solicit votes. And by the way, if there are other judges or justices on the court that disagree, or are unwilling to ascribe to different provisions, they can say, well, actually, if you take this out, you'll get my vote, right? So what the writer of the opinion is trying to do is they're trying to leverage what they actually want to write and what is acceptable to write, so they can get the most votes, right? And the reason you want the most votes, also, you need a majority for any court, for any opinion to become law, right? You need the majority, otherwise it's just kind of a dissent. But if you essentially have, if you don't have that opinion, right? If you don't have that majority, you know, you run into all sorts of other issues, right? But the majority aspect of it allows you to negotiate there. And that negotiation is what tends to moderate the law that comes out of courts, right? But so the other reason you want more votes is majority is good, but unanimous is better. So courts typically give more deference to, and obviously we've seen at the Supreme Court this isn't always the case, but at the lesser court levels, what tends to happen is that the more people have signed on out of a potential. So typically an appellate court has like 3 judges on it. So if you get all 3 judges to agree on something, other appellate courts are going to be really hesitant to overturn it. You essentially guarantee the longevity of a court opinion by the ability of the writing judge or justice to get more people on it, right? One of the reasons, so if we go all the way back in time to Brown v. Board of Education, one of the reasons that the justices were so adamant about getting a 9-0 is because they wanted to show that the whole court was agreeing on this particular thing, and that they would then future courts would hesitate to overturn Brown v. Board, right? And so every time there's a unanimous decision of the court, it's one of those things where typically it's created a kind of a blanket understanding across the political spectrum of we don't touch this, right? So every judge and every justice is trying very hard to reach unanimity, right, in all of their opinions. So the more people you can get on an opinion, the more likely you are to have whatever you've written last the test of time, right? And so in order to do that, you kind of play this negotiation game. And once it's leaked, once you actually get the leak out of the courts, what effectively happens is everyone who's signed on to it is essentially stuck there, right? Because regardless of how it looks for them individually, the people are going to respond in kind to whatever it is that's out there and whoever's aligned to what. So specifically with this leak, right, what is likely the most extreme version of a court opinion got put out there, and 5 justices ascribed to it. Now, if one of them tries to shy away from that, it's going to look really bad for them, but also because the judges also act in the political world in some ways, sometimes more than they should, but, judges can be impeached, right? So if there is a significant portion of a political body who is not interested in the position that they've taken, you could impeach a judge for that. There is no requirement in law that stops you from doing that, right? So you really do want this level of secrecy in the court so that you can get the most moderate court ruling out there. And I know that's not great, especially if we were ever in a situation where there are a lot of left-leaning justices and we really see, an amazing decision that was pro left-wing economically or whatever it's going to be, you would want that extreme version to get out there. But truthfully, in a lot of the cases, you want a decision where there's some level of consensus among the justices, because the courts are really supposed to moderate the power of the electors and the elected representatives and the president, right? And so because of that, you don't want really extreme judgments to come out of courts either way. You want more, you want stronger pieces of legislation to come out of legislatures systems, right? Because they're closest to the people, and you want moderation to come out of the courts. Okay, so that's aside, that's why the SCOTUS leak is bad. But we've heard a lot about why the SCOTUS leak is bad, and the people who have really been harping on that is the right wing in America. The Ben Shapiro's, Fox News, all that. They've really been like going crazy, like, oh my God, the leak is so bad. And I explained to you why the leak is bad, but why do they care so much? They just won a massive battle, right? They've been fighting for so long. They've been fighting for over 50 years. So the reason that they're really harping on this is because they know that, according to recent polling, 70% of the US is pro-choice, right? So because this is coming out now, right before a midterm election, the right wing really doesn't want to talk about their victory, because the more they talk about it, the less popular politically they become, and the more it has actual political implications for representatives and elected officials on the right. So one of the reasons that right-wing media is like going crazy about just the leaker, and they're really not talking about this victory that they got on the abortion issue, is because they know it's politically toxic for them. Okay, so just keep that in mind when you see people like shouting and screaming and this kind of stuff. And, another point I want to make on this is, there was talk about, especially on Fox News, about the leaker potentially being a liberal. A liberal doesn't want to leak this. A liberal would really want to make sure that only the most moderate version, the most pro-choice version, got leaked, right? But the version that got leaked with all these justices attached to it was the most extreme version, right? So a liberal wouldn't want this to get out because then you lock those justices and you lock that opinion in. So really, the leader was probably someone working for the conservative bench, right? Because they have an incentive, they have the want to get that most extreme version out there. And when they do that, they essentially cement that issue into the public sphere. So I think it's just kind of interesting, the whole conversation that's being had on the leaker or whatever. Again, not nearly as important as the context, which we're going to talk a lot more about. But I did just want to give you some, my opinions on the leak, the leaker, whatever. So let's talk about Roe, right? We're going to talk about Roe. So in my opinion, Roe was correctly decided, and it's not just because I'm pro-choice. If you look at the 14th Amendment, if you look at the way that the Equal Protection Clause of the Constitution is used, and I'm going to bring it up in a second and read it to you on screen here, you'll see that you can essentially take it to mean lots of things, right? And by the way, this is part of the issue that Alito has when he's writing his decision to overturn Roe, is that, oh, people are taking the 14th Amendment and just going crazy with it. And in some sense, he might be right, but if you think about the fundamentals underpinning the 14th Amendment, the equal protection of laws, you have to think about not only does the law as written protect individuals equally, but you also have to think about it the other way around. Do laws address equally across the board, right? So let's pull up the 14th Amendment, let's read it together, and then I'll continue on with this a little bit, okay? So I'm going to focus here on the very last line. All right, nor deny to any person within its jurisdiction the equal protection of the laws. Now, why is that particular portion so important? It's because if laws target particular groups of people, so only women, or let me put it this way, only people with uteruses can have abortions, right? That's just biologically, that's how it works. And because that's the way it works, there's a large portion of the population who does not have uteruses and to whom the law does not apply. So if you create abortion bans, you actually do not give people equal protection of the laws, because the law is targeting a particular group of people. So Roe, which is decided under, it's decided in under a combination of a bunch of amendments, specifically, but more specifically under the 14th Amendment, where lots of newer rights have come from, we talk about the equal protection of the laws. And so any law, in theory, any law created that discriminates against certain groups of people in the way that they are treated, with some exceptions, and we're talking about fundamental rights here, okay, then you violate the 14th Amendment. So an abortion ban obviously goes into this space. Now, right, Roe actually is a balancing test. It creates the trimester system. You have a whole series of pieces of the Roe decision that actually are very careful balancing acts between the parent, the birthing parent, and the child that is developing inside the parent, right? And because of this balance, you really get as close to the spirit of the 14th Amendment as you possibly can. Now, is it still true that any restriction on abortions or any laws having to do with reproductive health concerning people with uteruses are going to, in some way, violate the Equal Protection Clause because they single out a particular subset of the population? Yeah, absolutely. That's what's going to happen. But the truth of the matter is, you can get very close to the 14th Amendment protections by creating balancing tests, right? Like Roe did, saying, in the first trimester where the life is not independent, the birthing parent makes the decision, right? And on the other hand, in the third trimester, when the life is viable, the viability standard is set in the Casey decision, which will also be overturned, then that life has equal protection of the laws as the birthing parent does, right? We create the balancing test here, which I think is so important. So honestly, we have in the Roe decision, in my opinion, the closest possible balance that you can achieve between the equal protection of laws for all people, and the equal protection of laws for those individuals involved in birth, which are the birthing parent and the child. Okay, so we'll just bring this back off screen for a second. So why couldn't other sections of the U.S. Constitution be used to create the abortion right? Right. So a lot of people look at the general welfare clause of the Constitution, and I'm not going to pull it up for you, but essentially it says that the Congress has the ability to ensure the general welfare for individuals. Now, this is kind of way into the weeds from like a legal perspective, but way back then, essentially, it was decided that the general welfare clause was effectively useless. And the reason it was decided that way is because it's so broad, so the justices thought back in the day, that you could use it for anything, right? And if you could use it for anything, then the other restrictions that are given to the federal government and the state governments, because the Constitution has whole conversations with itself about what can states do, what can states not do, what can the federal government do, what can they not do, right? And so if you read the rest of the Constitution in line with the General Welfare Clause, it's really difficult to justify why all that other text was written, right? Because in theory, the whole Constitution could have just been the General Welfare Clause and some other information about how government should look, right? But it wasn't, right? The founding fathers, for all their flaws, were very careful about creating a balance of powers between states and the federal government, right? And so because of that, it's largely understood that the general welfare clause can't be used for things like this because it's just too broad, right? The general welfare clause is essentially an understanding that government should act in favor of its people. Okay, now something that our legislators have clearly forgotten in the last couple hundred years, but that's the idea of it, right? So it's less a mandate and it's more a reminder, hey, your job's to help the people who elected you. Okay, so how the the fundamental underpinning of Roe was the privacy right, the zones of privacy that are created in the First, Fourth, Ninth, and 14th Amendments. I'm not going to bring them all up, but you pretty much know all of them. The one you probably are not familiar with is the Ninth Amendment, so we're just going to go and give it a quick read real quick, okay? And so I'm going to just pull it up real quick. So you'll see the Ninth Amendment is the enumeration in the Constitution of certain rights shall not be construed to deny or disparage other retained by the people, right? So essentially, what this says is that just because some rights are created in the Constitution doesn't mean that other rights exist out there for people to have, right? And the Constitution specifically puts them in the hands of the people. So government can't take them from us. We as individuals are sovereign, right? We get these rights as an automatic. Government then has to, government then makes decisions on them. We can then choose as a people through referenda or through our legislative process to restrict those rights, expand those rights, et cetera, et cetera. Okay, but the rights are retained in people first, right? And by the way, it's very important that the Ninth Amendment sits above the 10th Amendment, which says to all rights not given to the federal government are provision to the states, right? The order of these two amendments, again, this is kind of in the weeds, so I apologize, gives the people more power than the states. It makes the individuals, you and me, the fundamental underpinning of government, okay? And I think that's a really cool thing. But essentially, in these four amendments, Roe finds that there are zones of privacy. And the reason the Ninth Amendment is included in there is because what we do on our own, in our own homes, is none of the business of the government, right? Because we are sovereign. We own our rights first and foremost, right? Rights can be given to us, but we possess the plethora of other rights that exist out there, okay? And we then elect people who can change, alter, expand, whatever those rights. Okay, but we have them inherently. So the zones of privacy that creates, essentially, that was the other way that Roe was decided to say, look, what you do on your own outside of harming anyone else is your business. Now, by the way, that harming anyone else bit is partially where the viability standard comes in Casey, right? Because then you're harming another person. Okay, so again, that just goes back to my point, which was Roe was well decided. And the last point I want to make on this, and this is one that we seem to forget a lot in America, is that we are a secular country. I know. I know. It seems like we have forgotten that. But truthfully, No document of religious literature, according to the First Amendment, can be used to make laws. Okay? So the Bible, whatever you believe it says, whatever it actually says, that information cannot be used, even if that information is purely secular, like thou shalt not kill, for example, in the Ten Commandments, right? Murder is a crime, but it's not a crime because the Bible says so. It's a crime because we fundamentally believe that murder is wrong. Okay? Now, is that informed by the Bible? Maybe, but we don't make these distinctions like that. Okay? About biblical law and secular law. We are a secular country, we make secular laws. So any provision in the Bible cannot be used to create secular law. And in this case, obviously, we're talking about abortion, but you could talk about pretty much anything. You could not make a secular law requiring a brother-in-law to marry his sister-in-law because his brother dies, right? The Bible requires that. In Leviticus, there is a section that says, hey, if your brother's wife dies, you have to marry her. That's your obligation, and you have to provide children by her. That we can't have that in a secular country, right? That's insane. Whether you believe that should be the case or not, obviously that doesn't undergird the interests of the state, right? So you cannot have that as a secular law. Circumcision, same way. Abortion, same thing. All these are biblical laws, and if you believe in them, great. You should practice them, okay? But you cannot use the power of the secular state to enforce these rules on other people because we have an amendment in this country that draws a line between church and state. The First Amendment protects individuals from the government telling them how they can't have a religion, and vice versa. It also protects people from religion. Let's pull it up. Let's look at the First Amendment, okay? Congress shall make no law respecting the establishment or religion, or prohibiting the free exercise thereof. Okay? So the government cannot stop you from practicing your religion in most cases. There are some cases where, ritual killings and things, the state has an interest in that. But for the most part, they can't stop you. So if you don't like abortions, if you are a person who believes that abortion is wrong, great news for you. Don't get one. Don't get one. The government cannot stop you from not getting an abortion. The government cannot force you to get an abortion if you believe that it's wrong. Okay? But at the same time, you cannot use that belief of yours to push abortion bans on other people who don't believe that that's the case, right? This is a decision that everyone makes on their own. Circumcision is the same. The weird thing about the brother's wife, I guess that works too. But you get the idea, right? So not only are we protected from the government telling us what religion we have to do, we're also protected if we don't want any religion at all, right? So that logic brings us to the inevitable conclusion that you can't use the Bible to make laws, okay? So I want to move on to why Alito wrote that he's going to strike down Roe. And so he talks about that, abortion is not in the Constitution and it's not a long-held right. Okay, back it up there, Chief. So the Constitution is a document that was written in the 1780s. A lot's changed since then. There are a lot of areas where we have updated our where we have updated our understanding of the laws. But on the other hand, like there are also some areas where we haven't done so. So like the Second Amendment, for example, the Constitution is a complicated document. Truthfully, and I've talked about this on the show before, the Second Amendment was effectively superseded by the creation of a national military. The whole purpose of having militias was to defend the states against invasion. Well, we have a national army now. There's no reason for militias. No one, Tom Wolfe doesn't give me a call and say, "Hey, we're being invaded. Can you pick up your musket and come to come to City Hall and defend Pennsylvania from whoever's invading us?" Right? That doesn't happen. Okay, we have National Guard, we have national armies, right? They were funded, they're professional soldiers. We don't have any of this. Militias were created in case that didn't exist, but it does, and it has since like 1790. Okay, so really, Second Amendment's kind of silly, but it doesn't matter. The point I'm trying to make here is, in some ways, we have updated our understanding of the laws, and in some ways, we have not. Okay, so the idea that saying, oh, something isn't a valid right because it's not in the Constitution is stupid. It just, like, it just doesn't vibe with the world that we live in. And the thing that's funny is that like traditionalists don't, and I'm going to talk more about this later, but they don't apply their standard across the board. Fundamentally, the traditionalists are really just applying whatever their politics are to the Constitution and then finding some Weasley way to make it work later. Okay. And so not only do I think the reasoning is very bad, but this leads to an integrity crisis for the court. So here's the thing about democratic institutions, and it's all democratic institutions, not just courts, is that in order for the court to be a valid institution in the United States, it requires the collective to believe in them. Not like Tinkerbell, but you get the idea, right? In And look, we saw this during the Trump administration too, and we were very worried that Trump was not going to respect the rule of law, right? Because he's got fascistic tendencies. But when the court said something, he respected it. In some ways, and this is like the lowest bar imaginable, so I'm not giving credit to Trump, okay? But in some ways, he perpetuated those institutions by following them when they critiqued him. Okay. Now he thought it was unfair and he complained about it and yada yada yada. But it doesn't matter. At the end of the day, he and all other people have said, you know what? A court said something, we're gonna back off. And so the more times that the court does things that are explicitly political, like this leaked decision, the more that individuals, and I don't just mean legislators, I mean like regular people, right? You and me, right? The more those people are going to question, are these institutions actively perpetuating the democratic values that we have? Because just like I read you in the Ninth Amendment, fundamentally, the underpinning of the US government, regardless of how you view it, is that the people are the most sovereign, the states are the next sovereign, and then the federal government is the least sovereign, except for in some cases, right? So if courts, who are an unelected branch of government, do things to impinge upon the sovereignty of individual citizens, we may stop believing that the court is in the best interest of the citizens who are the most sovereign, right? So this creates a crisis for the court. And the more times it does things like this, the more times it impinges on this sovereignty, the more times it acts undemocratically. And I mean that lowercase d, right? Without consideration to what the people want, to what the people believe, to how the country is changing, to the living document nature of our Constitution, the more people are going to say, screw it. We will not pay attention to the courts. We will do things beyond the courts. We will not allow the courts to stop us. And this is actually dangerous for democracy in general. So I hope and I plead that the Supreme Court is listening to all the people out there that are criticizing them for this, and not necessarily that they should change the way that they do things from a fundamental level, but that they should understand that their will is not independent of people, right? Of the understanding that we as citizens have about ourselves. And we can't pretend that the Supreme Court justices aren't looking at the news, right? That you can't stop them from owning cable. Okay? So you get to the situation where the court needs to, in order to maintain its legitimacy, reflect at some level a combination of the underpinning rules of society, which are our Constitution, and the living rules. Get my finger on the frame here. And the living rules that are made up by the greater opinions of the primary sovereign, which are the citizens. Now, obviously, there are some cases where you can't do this, right? So, you couldn't have a vote that says, X group of people are second-class citizens and therefore we can oppress them, right? Slavery, obviously, was kind of, and segregation and all those are kind of like the exact opposite, right? The people were in the wrong there. And so the Constitution, and by the way, it was manipulated in terrible ways too, right? There are whole clauses in the Constitution about slavery. But as we move towards the sovereign's beliefs that those institutions that we held up are bad, the court moves there too, right? So overturning of Plessy, and Brown v. Board and all of that, right? So it takes a while, and it's not a perfect system, and it's never going to be. Okay, I don't want you to come out of this thinking like there's a way for it to be perfect. There isn't. There is no way for it to be perfect. But there is a way for the courts to balance, right? Because it's all about balance. The rights of the system as a lowercase democratic system where all individuals choose their destiny, and the desires of the people who underpin that system, who are the destiny choosers, right? And the courts are meant to moderate that relationship, and they should do it in a balance. This is not a balance. Okay. Let me grab a quick drink of water, and then we can continue. Okay. Thank you for your patience. Okay. So the next thing is that, in relation to the last thing, abortion's not in the Constitution. Well, lots of things aren't in the Constitution that we do. Filibuster, not in the Constitution. Number of justices on the Supreme Court, not in the Constitution. The supremacy of the Electoral College, also not in the Constitution. And most interestingly, in Article 3, there is nothing about judicial review. Okay, so we're going to read Article 3, Section 1, and you're going to see that the fundamental power of the courts that they exercise today is not in the Constitution. Let's take a look. The judicial power of the United States, doesn't say what that is, shall be vested in one Supreme Court and in such inferior courts as Congress may from time to time ordain and establish. The judges, both the Supreme and Imperial Court, shall hold their offices during good behavior, that means for life, and shall at times receive for their service a compensation, we pay them a salary, which shall not be diminished during their continuance in office. So their salary can only go up. Great gig, right? Your salary can only increase. But you'll notice, and even in the second one, there is nothing about judicial review of laws. We invented that. One of the first Supreme Court cases ever, and I had it on the tip of my tongue, and I'm now forgetting it. Monroe versus Madison. Okay, the original case where the court was in crisis, and they decided, hey, we can create a spot for our own legitimacy by playing off the power of the president and the courts, and they created judicial review. Okay, judicial review did not exist before Marbury versus Madison. Marbury versus Madison, not Monroe versus Madison. Marbury versus Madison. Whew. Let's go law school. Okay, so that thing that we created and we've respected now for 100 and change years, closer to like 180, wasn't in the Constitution. We invented it. And by the way, that's part of the thing about traditions in democratic systems. They don't all have to be in the foundational document. We can just go forward with them. But it also means we can change them, right? Now, I actually think fundamentally judicial review is a fine thing. I think the court should be doing that because the way the courts were originally set up is just as dispute resolution systems. But it's hard to have that in a vacuum without the ability for the court to have some control over what laws can stand and what laws can't, right? So in some ways, and I talked about it before, right? The moderation between the courts and the people comes with this judicial review. So I actually think judicial review is a great thing. But again, up to my legitimacy point made earlier, you lose the legitimacy to do that, to fill that role if you don't act in such a way that is appropriate, okay? So all these things that we take for granted and that we don't like, right? Filibuster is garbage. But the supremacy of the Electoral College, that one was a deal between the two major political parties at the time. There was nothing in the Constitution. There is nothing in the Constitution that says one is greater than the other. It just says that they exist. So if they don't agree, then who wins, right? And so a political deal created that agreement. And so there's no reason we have to uphold that. We choose to, and we've acted that way for a long time. So essentially, the idea that every tradition that we have is in the Constitution is a fundamentally, how do I say this nicely, disingenuous reading of the Constitution. It just is. There is nothing in the Constitution that creates a lot of the things that we do And if we went by the standard that you can only do the things that are in the Constitution, we would be a very different and possibly incomplete democracy. We're still an incomplete democracy, but you get the idea, right? Okay. So the next point, and this is kind of my second to last point here, is I want to talk a little about living document theory, and you can kind of understand. Hopefully, I've kind of laid the groundwork to get to here. So, what is living document theory, right? So, living document theory is the idea, and this is so this it's the opposite of originalism, right? Is that as society moves forward in time, our foundational documents have to interpret the world in a continually evolving manner. Okay. And that continual evolution is what gives the Constitution the vagueness it requires to continue to undergird our fundamental principles. Okay. So the way that the document doesn't often change, but at the same time, our understanding of the document changes. And I want to read for you real quick Article 5. Okay, and for me, this is the strongest validation that living document theory is correct. Okay, I'm gonna put it up on screen and I'm gonna read it for you. The Congress, whenever 2/3 of both houses shall deem it necessary, shall propose amendments to this Constitution. Okay, or on the application of legislation to 2/3 of states, shall call a convention for proposing amendments. Okay, so let's stop right here. Automatically, we're not even done the first sentence. I think this whole thing is one sentence. Holy moly, these people didn't know how to use periods. But already we're like a couple lines in, and we can amend the Constitution. We can change our fundamental document. So obviously, this has to be a living document of some kind, right? All right. And, amendments, which in either case will be valid to all intents and purposes as part of this Constitution when ratified by the legislatures. Okay. Provided the amendment which be made prior to the year 1800. Yeah. Okay. Fine. So essentially, this portion of the Constitution says, hey, we didn't get it 100% right when we wrote this the first time, right? You can edit this document. You can make this document fit your purposes as history progresses. Because we, in our wisdom, founding fathers, recognize that the world will change. And part of the reason they knew that is because they were changing the world too. And this isn't to deify them or whatever, but they had the good sense to say, we're not the end all be all. Life will change after us. And so we need to give the people who come after us, because we want this country to last for a long time. We need to give those people the ability to change this document. And so to that end, we also read the Constitution that way. The Constitution is read sequentially. When we wanted to get rid of slavery, we wrote an amendment saying, hey, that text above, no good anymore. When we wanted to make the Senate direct democracy, right? Senators directly voted by the people, we wrote an amendment that says, that stuff before, no good, change it, right? Over and over and over again. 27 times, in fact, we have seen that the Constitution was not the document that we wanted it to be. And we changed it. And so the Constitution is meant to be changed. Our interpretation of that document is meant to be changed. It changes as we change. So that brings me to my last point. What now? Roe will be going away. Cases will be going away. But we have options. It's not totally hopeless. We can codify Roe versus Wade into law at the federal level. You can codify it at the state level. Okay? If we really had the votes, and we probably don't, we could amend the Constitution. We could add an abortion right. We could pass Medicare for all. We could ensure that that the law protects all individuals from health emergencies equally, right? There are so many things that we can do. Now, Biden said he's not going to change the filibuster for this, which is a fundamentally naive thing for him to say, but he said it, so it's out there. But we're not done yet. We can still save this right and make sure that regardless what a court says in the future, that the law of the land reflects the rights that we, the sovereign citizens, believe in. Remember the Ninth Amendment. The Founding Fathers gave us, regular people, the fundamental power underneath this government. 70% of Americans believe that abortion should be an option. Our government, which has the least sovereignty, needs to reflect the people, which has the most sovereignty. All right, guys. I will fill you in on whether we're having an episode next week. We'll kind of see how things go. Thank you so much for watching. I hope that you appreciated my breaking down of the leak concerning Roe versus Wade. And we'll see you next time. Take care, everybody.